Meghan Markle has won a legal challenge against the Mail on Sunday in a privacy case over a letter she sent to her estranged father. The newspaper's publisher, Associated Newspapers Limited, ANL, has lost its appeal in the latest round of the Duchess of Sussex's privacy battle over 5 articles that reproduced parts of a personal and private letter sent to her father Thomas in August 2018. The publisher is now considering a further appeal to the Supreme Court. Matthew Dando, this judgment is deeply troubling. The Court of Appeal's judgment is being trumpeted in certain circles as a victory against the press from which a reshaping of the industry should be born. But that mischaracterises the decision entirely. In one sense it is a judgment on a specific issue and a discrete set of facts focused on the Duchess letter, the previous article published in People magazine in the US and the Mail on Sunday articles alone. The court did not find that the Mail on Sunday was wrong to report on the rift between the Duchess and her father, or that the clear inaccuracies in the People magazine article did not stand to be corrected. It simply found that, weighing up those issues, the reporting had on this occasion overstepped the mark. In another sense, though, the repercussions of the decision are far-reaching and the consequences deeply troubling. It is astonishing that the High Court felt able to give judgment without even hearing key evidence regarding the preparation of the Duchess letter and its intended audience. By doing so, the court elevated the Duchess' privacy rights over matters of public interest and freedom of expression. It is a cornerstone of our adversarial justice system that evidence is tested at trial. Yet the only evidence the Duchess gave throughout the proceedings was to apologize for an inaccuracy in her case because she had not remembered having authorized her communications team to provide information to the authors of the book Finding Freedom, and had therefore misled the court. What the Court of Appeal described as an unfortunate lapse of memory at best is proof in itself of the importance of testing evidence under oath. The decision also heightens concerns that privacy laws permit public figures selectively to determine what can be reported about them, and gives wide scope for carefully coordinated public relations strategies whose sole purpose is to manipulate the narrative and curate carefully crafted public personas. Questions of the extent to which the Duchess letter was written with her media strategy in mind, an inference which was hard to avoid based on the involvement of her communications team, are important in determining where the line between privacy and freedom of expression should be drawn, and yet evidence on those points was just not allowed to be heard. No one would claim that the exercise of balancing privacy rights, public interest and freedom of expression is easy. Judges themselves often disagree on where the balance lies on any set of facts. This explains why wide editorial discretion is critical. If editors' decisions are tightly judged years down the line and after days of legal argument, then decisions made in the newsroom will inevitably become more conservative. Publishers will become more selective on what they print, and the real losers will be the British public. They will have less information at their disposal to decide the merits of issues for themselves, be more vulnerable to coercion by public relations strategists, and be kept far more in the dark than audiences in other liberal democracies with a far freer press. The Duchess, formerly known as American actress Meghan Markle, said the Court of Appeal ruling was a victory of right versus wrong. She issued a call to reshape a tabloid industry that has long been the bane of both celebrities and British royals. Losing claimant Associated Newspapers said it was considering an appeal to the UK Supreme Court.